Case 1. Annie Anderson. October 10, 2005. Maricopa County Superior Court. City of Phoenix, Arizona. She checked into that hotel room alone. No visitors. No family waiting in the lobby. No flowers on the bedside table. No one counting down the hours with her. Just a woman, a room, and a secret she had carried for months. A secret that was, by the early hours of October 10, 2005, about to change the course of multiple lives forever. The hotel sat within driving distance of one of the busiest airports in the American Southwest. Phoenix Sky Harbor International Airport processed tens of millions of travelers every single year. Business travelers, vacationers, families returning home from long journeys, college students heading off to new lives in new cities. The airport was, in every sense, a crossroads, a place where thousands of separate stories intersected every single day without ever really touching. On the morning of October 10, 2005, one more story began there. But this one would not be told in full for nearly 2 decades. Airport workers going about their early morning routines made a discovery that stopped everything cold. Inside a trash receptacle in one of the terminal areas, they found a newborn baby, a tiny infant, impossibly small, left behind in a place where no infant should ever be found. Emergency responders were called immediately. The child was transported to a medical facility with the kind of urgency that comes when every second matters. Against odds that left everyone who understood the situation quietly in awe, the baby survived. She was a girl. Because no one knew her name, because no identity had been given to her, no birth certificate filed, no family coming forward to claim her, she was given a name by the community that rallied around her story. They called her Baby Skylar, a name that carried in it something hopeful, something that reached upward toward possibility rather than downward toward despair. A name that said clearly and without hesitation, "We see you. We claim you. You are not forgotten. You matter." Baby Skylar spent the critical early days of her life receiving the medical attention that her fragile beginning had nearly denied her entirely. The community of Phoenix responded with an outpouring that said something profound about what people collectively believe a child deserves. Not abandonment, not a terminal trash can, but warmth and care, and someone willing to fight for her right to exist in this world. Law enforcement launched an investigation immediately. Who had left this infant? Who had given birth and then walked away from their own child without looking back? Investigators worked the case in 2005 with every tool available to them at the time. They canvassed the airport. They reviewed available evidence. They followed every lead that presented itself. But the woman who had, according to what investigators would eventually piece together, checked into a nearby Phoenix hotel, given birth alone in a bathtub, and then made the devastating decision to leave her newborn behind. She disappeared back into the current of ordinary life. The trail went cold, and baby Skylar grew up. She was adopted by a family who gave her the love and stability that her first hours on Earth had so cruelly withheld. She built a life. She became a young woman who carried, somewhere beneath the surface of her daily existence, the knowledge that her beginning had been different, that someone had made a choice, that she had been left behind in an airport terminal, and that for 18 years, no one had been held accountable for what happened to her on the day she entered this world. The case file gathered dust. The years passed, and then the world of investigative science changed in a way that would prove decisive. Investigative genetic genealogy, a discipline that uses DNA analysis combined with genealogical research to identify unknown individuals, had already solved cases that once seemed permanently closed. It had brought answers to families who had spent decades living without them. It had placed names on remains that had gone unidentified for years. And in 2021, law enforcement applied this powerful tool to the baby Skylar case. What followed was the kind of investigative breakthrough that reminds everyone paying attention why it is so important never to close the door entirely on a case just because years have passed. Investigators, working through DNA evidence and the painstaking genealogical research that this methodology demands, identified a woman named Annie Anderson as the biological mother of baby Skylar. The identification was the product of serious, methodical scientific work. It was not a lucky guess. It was not a coincidence. It was the result of dedicated investigators refusing to accept that a child could be abandoned at an airport and that no one would ever answer for it. But identifying someone and locating them are two separate challenges. And Annie Anderson, in the 16 years since October 10, 2005, had not remained in Phoenix. By the time investigators had her name, she was living in the state of Washington, far from Arizona, far from Sky Harbor Airport, far from the hotel room where everything began. In December of 2023, law enforcement located Annie Anderson in Washington state and placed her under arrest. She was taken into custody on charges that reflected the full weight of what prosecutors believed had occurred on that October morning nearly 2 decades earlier. The charges filed against her in Maricopa County included first-degree murder and child abuse. The arrest sent ripples through a community that had never forgotten baby Skylar. News outlets that had covered the original discovery back in 2005 now carried the story of the arrest with the kind of urgency reserved for moments when justice, long delayed, finally begins to move. People who had followed the case for years found themselves reading headlines they had genuinely wondered if they would ever see. Baby Skylar, now a grown woman with her own identity, her own name, her own life built in the years since her adoption, was no longer just a story. She was a survivor. And the woman prosecutors believed had left her behind was now facing the full consequences of that choice in a court of law. As of May 2026, Annie Anderson's trial in Maricopa County Superior Court is scheduled for September 15, 2026. The legal proceedings that will follow represent more than just one case moving through the justice system. They represent the principle that children deserve protection from the moment they draw their first breath. They represent the belief that accountability does not expire simply because time passes. They represent the promise embedded in the work of investigators who kept working, kept asking questions, kept believing that science would eventually provide what ordinary investigative methods could not. The child who was left in a trash can at Phoenix Sky Harbor International Airport on October 10, 2005, survived. She grew. She lived. And now, on the eve of a trial that has been almost 21 years in the making, the full story of what happened to her on the day of her birth is finally being told in the only place where it truly belongs, in a court of justice, before a judge, before a jury, and before the public that never stopped caring about a baby girl they named Skylar. Organizations like the Child Help National Child Abuse Hotline, reachable at 1-800-422-4453, exist precisely because every child deserves an advocate. If you know of a child in danger, please make the call. Your action could be the difference between a tragedy and a rescue. The justice system moved slowly in this case, but it moved. And for baby Skylar, that movement represents something that cannot be measured in legal terms alone. It represents the recognition that her life mattered from the very first moment. That what happened to her on the morning of October 10, 2005, was not something the world would simply absorb and forget. That someone would be made to answer for it. The trial of Annie Anderson is coming, and Phoenix is watching. If this case moved you, if it reminded you why stories like this one need to be told, please take a moment right now to show your support. Don't forget to like this video, leave a comment below, and hit that subscribe button so you never miss another story from Cold Case Hour. Your support keeps this channel going and keeps these important stories in front of the people who need to hear them. Case 2, Vallow Daybell. September 8 through 9, 2019, Tylee Ryan. September 22 through 23, 2019, J.J. Vallow. Maricopa County Superior Court. City of Phoenix, Arizona. There are cases that test the limits of comprehension. Cases where the facts, laid out plainly and in order, still somehow refuse to arrange themselves into a picture that makes sense. Cases where investigators, prosecutors, journalists, and ordinary people watching from the outside all arrive at the same stunned conclusion. That what happened was not the product of ordinary human darkness, but something far more difficult to categorize or explain. The case of Vallow Daybell is one of those cases. To understand the full weight of what prosecutors built against Vallow Daybell in Arizona, it is necessary to start not in Idaho, where two of the most devastating events in this story unfolded, but here, in the greater Phoenix metropolitan area, where the trajectory of destruction first became visible to those who knew where to look. Vallow had been married multiple times before she entered the relationship that would define her criminal history and ultimately consumed the lives of people who loved her. By the time she met Chad Daybell, a man who shared her increasingly extreme religious beliefs about death, spirituality, and the supposed spiritual status of people around them. She was already moving through a period of her life that those who knew her described as a profound and alarming transformation. The warm, energetic woman some remembered had given way to something harder and stranger, animated by beliefs that would have seemed eccentric in isolation but proved catastrophic in combination with the events that followed. On July 11, 2019, in the city of Chandler, part of the Phoenix metropolitan area in Maricopa County, Lori's fourth husband, Charles Vallow, was shot and lost his life. The shooting took place inside the family home. It was Lori's brother, Alex Cox, who pulled the trigger. Cox claimed at the time that the shooting was an act of self-defense, that Charles Vallow had attacked him, and that he had acted to protect himself. Law enforcement at the time accepted this account, and no charges were filed against Cox in connection with Charles Vallow's passing. But the questions that surrounded that July morning in Chandler did not go away. They multiplied. What had led to that confrontation? What was the true nature of the relationship between Lori Vallow and her brother Alex Cox? What role, if any, did the belief system that Lori and Chad Daybell shared, a system that reportedly involved identifying people as zombies or dark spiritual entities who needed to be removed from the world, play in what happened inside that Maricopa County home on July 11, 2019? Investigators would spend years building answers to those questions, and what they found was a picture far darker than the self-defense claim had suggested. Less than 2 months after Charles Vallow lost his life in Chandler, Lori's two children, 17-year-old Tylee Ryan and 7-year-old JJ Vallow, were last seen alive. Tylee was last confirmed alive on September 8, 2019, when she and JJ visited Yellowstone National Park with Lori and Chad Daybell. It was a trip that investigators would later examine with painstaking care. JJ was last seen alive on September 22, 2019. Within weeks, both children had effectively vanished. When family members, including JJ's grandparents, Kay and Larry Woodcock, who had loved that little boy with every fiber of their being, began asking questions and demanding answers about where the children were, Lori Vallow offered explanations that shifted and changed. The children were fine. They were with other family members. There was no cause for concern. The questions, in her telling, were intrusive and unnecessary. But the grandparents did not stop asking. And eventually, law enforcement in Idaho began asking too. In January of 2020, Idaho police conducted a welfare check at the home Chad Daybell shared with Lori. They had married in November of 2019, just weeks after Chad's previous wife, Tammy Daybell, had passed away under circumstances that would later be found suspicious. Lori told investigators that JJ was with a family friend in Arizona. She was unable to produce the children. She was given a short window to provide proof that the children were safe and accounted for. She could not do it. In February of 2020, Lori Vallow Daybell was arrested in Hawaii, where she had relocated with Chad after Idaho authorities began pressing for answers on charges related to the welfare of her children. She was extradited back to Idaho. In June of 2020, investigators executed a search warrant at Chad Daybell's Idaho property. What they found there ended any remaining uncertainty about what had happened to Tylee Ryan and JJ Vallow. The children's remains were discovered on the property. The full scope of what Lori Vallow Daybell and Chad Daybell had done, and what investigators believed had motivated it, began to emerge in devastating detail. The legal process that followed was extensive, multi-jurisdictional, and emotionally devastating for everyone connected to the children's lives. In Idaho, Lori Vallow Daybell was convicted and sentenced to life in prison without the possibility of parole for the loss of her two children and the passing of Tammy Daybell. Chad Daybell was separately convicted and faces the possibility of the death penalty in Idaho. But the state of Arizona had not finished with Lori Vallow Daybell. Arizona prosecutors built a separate case focused on events that had their roots in Maricopa County, the passing of Charles Vallow in Chandler, and an attempted attack on Brandon Boudreaux, Lori's niece's former husband, who was shot at in Gilbert, Arizona, in October of 2019. Investigators believed Alex Cox had carried out the Boudreaux shooting as well, acting on behalf of or at the direction of Lori. Alex Cox himself passed away in December of 2019 before he could face charges. In July of 2025, following the Arizona legal proceedings, Vallow Daybell was sentenced to life without parole in Arizona for her role in conspiring to bring about the passing of Charles Vallow and for the attempted harm done to Brandon Boudreaux. The Arizona sentence ran alongside the Idaho sentence already in place. Vallow Daybell will not walk free, not in this lifetime. For the families of Tylee Ryan and J.J. Vallow, children who deserve to grow up, to become who they were going to become, to live out the full arc of lives that were taken from them. The sentences represent accountability, even if they cannot provide consolation. Tylee was 17 years old. She had her whole life ahead of her. J.J. was 7 years old. He was a little boy who loved his family and was loved fiercely in return. Their grandparents Kay and Larry Woodcock, who refused to stop asking questions and refused to accept the shifting stories and the silence, played a role in bringing this case to its conclusion that cannot be overstated. They are a reminder that advocacy, persistence, and the refusal to accept that a child simply disappears without consequence can genuinely change what happens next. The passing of Charles Vallow on July 11, 2019, in Chandler, Maricopa County, the event that, in the timeline of this case, set so much else in motion, was the beginning of a chain of devastation that crossed state lines and claimed multiple lives. Arizona's role in that chain, and Arizona's accountability for it, was established in the courtroom in 2025. Justice, in this case, was not swift, but it was complete. If you are watching this and you have never heard of Kay and Larry Woodcock, look them up. Their fight for their grandchildren is one of the most powerful examples of what love looks like when it refuses to quit. And if this case has affected you, please reach out to the National Center for Missing and Exploited Children at 1-800-THE-LOST, 1-800-843-5678. They exist to make sure no child disappears without someone fighting to bring them home. Don't forget to like this video, drop a comment below, and subscribe to Cold Case Hour. Every like and every subscription tells YouTube that this content matters, and it helps this channel keep telling these important stories. Case 3. Jerice Hunter. Between September and October 11, 2011. Maricopa County Superior Court. City of Phoenix, Arizona. There is a particular kind of silence that investigators describe when they walk into a home where something has gone terribly wrong, but where the surface of things still looks almost ordinary. The furniture is in place. The dishes may be in the drying rack. The television might be on. Everything appears, at a passing glance, to be the way it should be. And yet something is profoundly, unmistakably absent. A presence that should be there is not. And the silence where that presence should be is louder than anything else in the room. On October 11, 2011, a woman named Jerice Hunter walked into a police station in Glendale, part of the greater Phoenix metropolitan area in Maricopa County, and reported that her 5-year-old daughter, Jessie Shockley, was missing. Jessie, 5 years old, a child with a face that, once investigators began circulating her photograph in the weeks that followed, would become one of the most recognized missing children in Arizona history. A little girl with a wide smile and eyes that looked back at the camera with the kind of directness that belongs to children who have not yet learned to guard themselves from the world. Jerice Hunter told investigators that she had last seen Jessie at home, that the child had been there and then was not, that she did not know what had happened to her daughter or where she had gone. The report triggered an immediate and intensive search. The Glendale community came together in a way that spoke to how deeply the disappearance of a small child registers in the collective conscience of a neighborhood. Search volunteers turned out. Tips came in. The investigation moved with urgency because when a 5-year-old is reported missing, every hour that passes carries weight. But as investigators dug deeper into the circumstances surrounding Jessie's disappearance, the picture that emerged was not the one Jerice Hunter had presented to them. The questions investigators asked did not produce consistent answers. The timeline Jerice offered had gaps in it that did not close. And those who knew the family, those who had been in the orbit of this mother and this child, began to provide information that pulled the case in a deeply troubling direction. Court records and investigative findings established that Jessie Shockley had not simply walked out of the house and vanished. What investigators came to believe, and what a jury would ultimately find beyond a reasonable doubt, was that Jessie had been subjected to serious, sustained harm within the home she shared with her mother. According to what the investigation established, the child had endured circumstances in the weeks leading up to October 11th that no child should ever be forced to endure. She had been confined. She had suffered. And at some point in late September of 2011, before her mother ever walked into that police station to report her missing, Jessie Shockley had taken her last breath. The act of reporting a child missing, coming to law enforcement, and saying my daughter is gone, was, in the context of what investigators came to believe, not an act of a desperate mother searching for her child. It was, in the investigators' assessment, part of an attempt to create a narrative that would explain the absence of a little girl who had already lost her life within the walls of that home. What followed was one of the most extensive and emotionally wrenching searches in the history of Maricopa County. Because Jessie's body had to be found. Because without her remains, there could be no full accounting of what she had endured. Without her, there was a hole in the case that all the witness testimony and all the investigative work in the world could not entirely fill in the way that finding her would have. Investigators searched landfills. They searched with a determination and a thoroughness that spoke to the commitment of every person involved to give this child the dignity of being found, of being brought back, of having her story told completely and without omission. Teams worked through conditions that were physically demanding and emotionally brutal. They searched and they searched and they searched. Jessie Shockley's remains were never found. That fact, that a 5-year-old child who deserved to be held and protected and celebrated and loved was never brought home in the way that every victim deserves, sits at the center of this case like a wound that will not fully close. The investigators who worked those landfill searches carry it. The volunteers who helped carry it. The community that rallied around her photograph carries it. But the absence of her remains did not stop justice from moving forward. Prosecutors built their case on the totality of the evidence available. Witness accounts, investigative findings, the reconstruction of what had happened in the Hunter home in the weeks before Jessie was reported missing, and the deeply inconsistent story that Jerice Hunter had told from the beginning. The case went to trial in Maricopa County Superior Court. Jerice Hunter was convicted of first-degree murder in the passing of her daughter, Jessie Shockley. She was sentenced to life in prison. The conviction was a statement from the justice system, a statement that said clearly, the absence of a body does not mean the absence of accountability. The absence of remains does not mean the absence of truth. We know what happened in that home. We know what was done to this child. And we will hold the person responsible for it fully accountable for what they chose to do. For Jessie Shockley, justice came in a courtroom rather than in a recovery. It came in a verdict rather than in a funeral with closure. It came in a sentence rather than in the return that her community had prayed and searched for with everything they had. It is not the ending anyone wanted, but it is the ending that the evidence supported. And in a case where a 5-year-old child was never allowed to grow up, the accountability of the justice system is the last form of advocacy available to her. Jessie Shockley was 5 years old. She deserved every single day she did not get. If you are in a position to support organizations that fight for children who cannot fight for themselves, please consider reaching out to the Arizona chapter of the National Children's Alliance. The work they do to support child victims and their families is precisely the kind of response that cases like Jessie's demand. Don't forget to like this video, leave a comment, and hit subscribe. You being here and staying until the end of each case is how Cold Case Hour keeps telling these stories. We appreciate every single one of you. Case 4, Octavia Rogers. June 2, 2016. Maricopa County Superior Court. City of Phoenix, Arizona, North Phoenix. There are moments in law enforcement history that become reference points. Moments that investigators and prosecutors and courtroom observers return to when they are trying to explain what the justice system is designed to do. Not just in cases of clear premeditation, not just in cases where the facts are straightforward and the motive is legible, but in cases where the events themselves are so far outside ordinary experience that the legal system is forced to ask hard questions about culpability, mental state, and the boundaries of accountability. June 2, 2016, in a residential neighborhood in North Phoenix, Maricopa County, became one of those reference points. On that afternoon, emergency responders received a call from a home in the North Phoenix area that brought them to a scene that would remain with everyone present for the rest of their professional lives. Inside that home, investigators found 3 children, a boy of 8 years old, a boy of 5 years old, and an infant boy of 2 months old. All three had been subjected to catastrophic harm at the hands of the one person in the world who was supposed to be their greatest protector. Their mother, Octavia Rogers, was present. What she had done to her 3 sons inside that home, the nature and the extent of the harm she had caused, was of a severity that medical examiners and investigators described in terms that conveyed the full enormity of what those children had experienced. The harm done to them was not incidental. It was not the result of a momentary lapse of judgment. It was severe, direct, and carried out within the walls of a home that should have been the safest place on earth for 3 young boys. The 8-year-old, the 5-year-old, the 2-month-old. 3 children whose lives were altered irrevocably on the afternoon of June 2, 2016, in a moment that law enforcement, prosecutors, and the broader public struggled to contextualize even as they worked to ensure that full accountability would follow. The question that the legal process in this case was ultimately required to answer was not simply what Octavia Rogers had done. The evidence established that with a clarity that was not in dispute, but why? And more specifically, what her mental state had been in the moments when she acted. What, if anything, was happening inside the mind of this woman as she caused harm to her own sons? That question took years to work through. The legal proceedings that followed June 2, 2016, were extensive and involved serious examination of Rogers' psychological and psychiatric history, her mental state at the time of the offenses, and the question of whether she met the legal standard for the guilty except insane determination that Arizona law provides for. In August of 2024, 8 years after the events of June 2, Octavia Rogers accepted a plea arrangement in Maricopa County Superior Court. The plea was guilty except insane. Under Arizona law, this determination acknowledges that the defendant committed the acts with which they are charged, but establishes that, at the time of those acts, the defendant was suffering from a mental disease or defect that met the legal threshold for the insanity defense. The consequence of that determination in Rogers' case was commitment to the Arizona State Hospital rather than a traditional prison sentence. She was placed in the care of a psychiatric facility, an outcome that reflected the legal finding about her mental state at the time of the offenses. The outcome of this case is one that invariably generates discussion about the nature of justice, the purpose of the legal system, and what accountability looks like when the person who caused harm was, in the eyes of the law, not in possession of the mental clarity required for full criminal responsibility. Those discussions are important and legitimate. They are part of how a society works through the hardest questions that cases like this one force it to confront. What is not in discussion, what the law and the facts establish without ambiguity, is that on June 2, 2016, 3 small boys in a North Phoenix home were subjected to catastrophic harm. The 8-year-old, the 5-year-old, the 2-month-old. Their lives were changed permanently by what happened to them that afternoon. And the justice system, working through years of legal process and psychiatric evaluation, arrived at the determination that it was designed to arrive at, one that accounted for both the acts committed and the mental state of the person who committed them. For the 3 children at the center of this case, the hope is that they have received, in the years since June of 2016, the care and support and therapeutic resources that they needed and deserved. The trauma that children carry from experiences of profound harm within the home does not disappear when the legal case closes. It requires sustained attention, compassionate intervention, and the kind of long-term support that organizations specializing in childhood trauma are equipped to provide. If you or someone you know is working with a child who has experienced trauma, the Child Welfare Information Gateway at childwelfare.gov provides resources, research, and referrals that can make a genuine difference in the life of a child who needs support. The case of Octavia Rogers is a reminder that the justice system is built not only to punish but to assess, not only to convict but to understand, and in understanding, to respond in a way that the full complexity of human behavior sometimes demands. Don't forget to like this video and subscribe to Cold Case Hour for more stories that examine the truth behind the cases that shaped communities across America. Leave a comment and let us know your thoughts on how the justice system handled this case. Case 5, Wanda Jean Johnson. March 11, 2024. Maricopa County Superior Court. City of Phoenix, Arizona. There is a category of cases that arrives in a courtroom and forces every person in the room, the judge, the attorneys, the jury, the members of the public seated in the gallery, to sit very still with the weight of what they are hearing. Cases where the victim was so small, so new to the world, so entirely dependent on the person who caused them harm, that the facts of the case resist being absorbed in the way that ordinary information is absorbed. They land differently. They stay differently. The case of Wanda Jean Johnson and the passing of her 3-month-old daughter is one of those cases. On March 11, 2024, in the city of Phoenix, Maricopa County, a 3-month-old infant girl, a baby who had been in this world for fewer than 100 days, was brought to a medical facility in a condition that demanded immediate and intensive medical intervention. The injuries the child had sustained were severe. They were internal. They were of a nature that medical professionals recognized as inconsistent with any accidental cause. The infant did not survive. She passed away on March 12, 2024, one day after she was brought to the hospital. She was 3 months old. What investigators established in the weeks and months that followed was that the injuries this child had sustained were the result of a specific action taken by her mother, Wanda Jean Johnson. According to the investigative findings and the charges filed, Johnson had performed what she described as a kind of physical adjustment on the infant, an action involving the baby's back that caused internal injuries of devastating severity. The infant sustained a serious brain injury, fractures to her ribs, and internal organ damage. A 3-month-old child. The human body at 3 months of age is not designed to absorb force. An infant's bones are developing. An infant's internal structures are fragile in ways that every medical professional, every parenting resource, and every piece of guidance given to new parents addresses with absolute clarity. Infants must be handled with gentleness. They cannot communicate when they are in pain. They cannot say stop. They cannot protect themselves. They depend entirely on the people caring for them to understand that their smallness demands a specific and unwavering standard of care. That standard was not met on March 11, 2024. In August of 2024, law enforcement arrested Wanda Jean Johnson and placed her before the court in Maricopa County on a charge of first-degree murder. The charge reflected the severity of what investigators had determined, that the action taken on March 11th was not an accident, not an oversight, not the result of ignorance about the fragility of an infant, but an act that the law views as criminally responsible for the loss of a child's life. As of the time of this documentary, the case of Wanda Jean Johnson is working its way through the Maricopa County Superior Court system. The legal proceedings will determine the full measure of accountability that the court assigns to what happened on March 11, 2024, in Phoenix. The 3-month-old girl at the center of this case had a name. She had a face. She had the whole of her life ahead of her, the milestones she would never reach, the words she would never say, the person she would never get to become. All of that was taken from her in a moment that should never have happened. When a child this young loses her life under circumstances like these, the community that surrounds that family and that neighborhood carries a responsibility to recognize the warning signs of harm in the households of people around them, to speak up when something does not seem right, and to understand that the protection of children is not solely the responsibility of law enforcement. It is a community function. It requires all of us. The Child Help National Child Abuse Hotline, 1-800-422-4453, is available 24 hours a day, 7 days a week, for anyone who is concerned about the safety of a child. A call to that line could save a life. It is that simple. For the infant girl who lost her life on March 12, 2024, the hope that this documentary carries is that her story, told here with the care and seriousness it deserves, contributes in some small way to a world that takes the protection of its most vulnerable members more seriously. That someone watching this video thinks about the children around them. That someone who has been hesitating to make a call decides to make it. Her life was brief, but it mattered. And the accountability that is moving through Maricopa County Superior Court on her behalf matters too. Don't forget to like this video, leave a comment below, and subscribe to Cold Case Hour. These stories are told because the victims deserve to be remembered, and because the communities they came from deserve to know the truth. Case 6, Denise Janelle Snow-Ingram. July 2013, Continuous Neglect. Maricopa County Superior Court. City of Phoenix, Arizona. Some of the most devastating cases that pass through the justice system do not arrive with a single moment of violence at their center. They arrive instead with a timeline, a long, slow, terrible timeline of days and weeks and months during which a child suffered not in one catastrophic instant, but gradually, accumulating harm in the silence of a home where no one from the outside world could see what was happening. The case of Denise Janelle Snow-Ingram and the passing of her 16-month-old daughter is exactly that kind of case. The child at the center of this story was 16 months old. She should have been walking, pulling herself up on furniture, discovering the world with the boundless curiosity that belongs to children at that age. She should have been gaining weight, growing, developing. She should have been, by any measure available, the most important focus of the adult life of the woman responsible for her care. Instead, she was suffering. What investigators and medical professionals established when this child came to their attention was a picture of deprivation so complete and so prolonged that it registered not just as neglect in the ordinary legal sense, but as a sustained failure of care that had, over the course of months, reduced a 16-month-old child to a physical state that shocked the medical professionals who examined her. The child weighed only 8 pounds. 8 pounds. A weight that would be considered low for a newborn, let alone for a child who had been in the world for 16 months and should have been thriving. Medical examination revealed that the child was suffering from rickets, a condition caused by severe and prolonged nutritional deficiency, specifically the absence of the vitamins and minerals that a growing child's body requires. Rickets causes bones to soften and weaken. It causes developmental delays. It causes pain. It is a condition that does not develop overnight. It is the product of months of deprivation. It is the body's record of a prolonged failure to receive what it needed to survive and develop. 8 pounds. Rickets. 16 months old. Each of those facts is a chapter in a story of neglect that unfolded across the summer of 2013 and beyond. A story in which a child who could not speak for herself, could not walk out of her situation, could not call for help or explain to a neighbor what was happening inside that Phoenix home, endured what she endured in the silence of a domestic space that was supposed to be safe. The child did not survive. When investigators built the case against Denise Janelle Snow-Ingram, they were constructing the record of a prolonged failure, not a single act but a pattern, a sustained absence of the basic necessities of life that a parent is legally and morally obligated to provide. Food, medical care, the fundamental nourishment that a growing child needs to exist. Snow-Ingram was charged and prosecuted in Maricopa County Superior Court for the passing of her daughter. The legal process worked through the evidence and the timeline that investigators had assembled, the medical records, the weight, the physical condition of the child, the absence of appropriate medical intervention during the months when the signs of the child's deterioration should have been impossible to miss. In January of 2024, more than a decade after the events of the summer of 2013, Denise Janelle Snow-Ingram was sentenced to 37 years in prison. 37 years. A sentence that the court imposed in recognition of the severity and the duration of what this child had been subjected to, and of the fact that the harm caused to her was not the product of a moment of failure, but of a prolonged and catastrophic abdication of parental responsibility. 37 years is a long time. It is, in many respects, longer than the child at the center of this case ever had the chance to live. She was 16 months old when she took her last breath. She will never know what it is to grow up. She will never know what it is to go to school, to make a friend, to discover something she loves, to become the person she had the potential to become. What she endured in her 16 months on this earth was not something any child should ever experience. It was a failure of the most fundamental kind, a failure of the basic duty of care that is the bedrock of what it means to be a parent. The sentence of 37 years represents the justice system's response to that failure. It represents the accounting that the law demands when a child is allowed to suffer over a period of months without intervention, without nourishment, without the medical care that could have saved her life. Cases like this one exist as a reminder of why mandatory reporting laws matter, why neighbors matter, why pediatric checkups matter, why the adults in the community around a young family have a role to play in the safety of the children within it. Most children who are suffering inside their homes do not have a way to tell the world what is happening to them. They rely on the world to notice, to ask questions, to make the call. If you are concerned about a child's well-being, please do not wait. The Arizona Department of Child Safety operates a hotline at 8775-437-633. A single call from a concerned adult can be the thing that stands between a child and the trajectory that this 16-month-old girl was never pulled back from. Her story deserves to be told. Her suffering deserves to be acknowledged. And the accountability that finally arrived in January of 2024, more than 10 years after she lost her life, deserves to be recognized for what it is, a statement from the justice system that the lives of the smallest and most vulnerable among us are not expendable. If this case stayed with you, if it made you think about the children in your community who may not have someone speaking up for them, please like this video, leave a comment, and subscribe to Cold Case Hour. Your engagement keeps this channel running and these stories reaching the audiences that need to hear them. We couldn't verify Case 7, so it will not be included. Our team is committed to presenting only verified true crime cases to ensure accuracy and credibility for our audience. Let's move to Case 8. Case 8, Rachel Henry. January 20, 2020. Maricopa County Superior Court. City of Phoenix, Arizona, South Phoenix. Monday, January 20th, 2020. In neighborhoods across South Phoenix, the day began the way most winter Mondays begin, with the ordinary rhythms of people moving through their lives, doing the things that need to be done, carrying whatever they are carrying quietly and without announcement. Inside a home in South Phoenix that day, Rachel Henry was alone with her 3 children, a 3-year-old, a 2-year-old, an infant of 7 months. By the end of that day, all 3 children were gone. The facts of this case, as established through Rachel Henry's own confession and as confirmed through the investigations and legal proceedings that followed, represent one of the most devastating events in the recent criminal history of Maricopa County. What happened inside that South Phoenix home on January 20th, 2020, is the kind of reality that the human mind instinctively resists accepting because it requires accepting something about the capacity for harm that most people prefer to believe is impossible. Rachel Henry confessed to taking the lives of her 3 children one by one inside their home. The 3-year-old, the 2-year-old, the 7-month-old infant. Each of her children, each of them dependent on her in ways that were total and without qualification. None of them capable of understanding what was happening or of doing anything to protect themselves from the person they trusted most completely. What drives a mother to that point? What combination of circumstances, mental state, despair, and decision-making leads to an afternoon in South Phoenix, where 3 children who woke up that morning and expected the ordinary continuity of their young lives instead encountered something incomprehensible? Those questions were examined as part of the legal process that followed the events of January 20th, 2020. They are questions that do not have easy answers. They are questions that professionals in mental health, law enforcement, and child welfare have been working to understand for as long as cases like this one have existed. And they are questions that, however they are answered, do not alter the fundamental reality of what happened. That 3 children lost their lives, that they were the most innocent of victims, and that the person responsible for their safety was the person who caused them harm. Rachel Henry was arrested and charged in Maricopa County with 3 counts of first-degree murder, 1 count for each of her children. The legal proceedings that followed were extensive. They included examination of Henry's mental state, her circumstances in the period leading up to January 20th, and the events of that Monday in South Phoenix, as she described them in her own words. On February 14th, 2025, 5 years after the events of January 20th, 2020, Rachel Henry appeared before the court in Maricopa County and entered guilty pleas to 3 counts of first-degree murder. The court accepted those pleas and proceeded to sentencing. She was sentenced to 3 consecutive life terms in prison without the possibility of parole. 3 consecutive life sentences. 1 for the 3-year-old, 1 for the 2-year-old, 1 for the 7-month-old. 3 children who existed and mattered and who are remembered. The sentence handed down on February 14th, 2025, represented the court's full and unambiguous statement about the value of those 3 lives. 3 consecutive terms, without parole, is the justice system saying in the clearest possible terms, what happened in that South Phoenix home on January 20th, 2020, will be accounted for. Completely. Without reduction. without the possibility that the woman responsible will one day walk out of a prison and back into the world as though those 3 children never existed. For families, communities, and advocates who work on behalf of children, the outcome of this case carries a message that matters. It carries the message that the lives of a 3-year-old, a 2-year-old, and a 7-month-old infant are not abstractions. They are not statistics. They are real. Their absence is real. The grief their extended family carries is real. And the accountability that the justice system delivered on February 14, 2025, is real. The mental health resources available to parents who are in crisis are real too. If you are a parent who is struggling, if the weight of what you are carrying feels impossible, if you are in a place of despair that seems to have no exit, please reach out. The crisis text line is available by texting HOME to 741741. The National Parent Helpline is reachable at 1-800-243-7337. Help exists. It is available. And reaching for it is not weakness. It is the most important thing a parent in crisis can do for their children. Rachel Henry will spend the rest of her life in prison. The 3 children she harmed on January 20, 2020 will not be forgotten. Not by their family. Not by this community. Not by this channel. If this story affected you, please take a moment to like this video, leave a comment, and subscribe to Cold Case Hour. These stories are shared because silence does not serve victims. Only truth does. Case 9, Natalie Tate. September 2024. Maricopa County Superior Court. City of Phoenix, Arizona. His name was Jody Jackson. He was 18 months old. He had a name. He had a face. He had the particular, irreplaceable quality that belongs to children at 18 months. The age where personality is fully present, where a child knows the people in their life and responds to them, where the world is large and new and entirely full of things to discover. At 18 months old, a child is in the full bloom of early childhood. They are not newborns. They are not abstractions. They are small people, vivid and present and entirely real. Jody Jackson lost his life in September of 2024 in Phoenix, Maricopa County, Arizona. The circumstances of his passing were established through the investigation and legal proceedings that followed, circumstances that placed the responsibility for what happened to him squarely and undeniably on the shoulders of his mother, Natalie Tate. According to the investigative findings and the court record that followed, Jody Jackson came into contact with fentanyl, a synthetic substance of extraordinary potency, dangerous to adults in small quantities and catastrophically dangerous to a child of 18 months in any quantity. The fentanyl that Jody was exposed to had been left within his reach. His mother, Natalie Tate, was under the influence of drugs at the time. The combination of those two facts, medication left accessible, a parent not in a state to supervise, produced a tragedy that was preventable at every single stage. Jody did not survive his exposure to that substance. He was 18 months old. The investigation that followed Jody's passing moved with the thoroughness that cases involving child endangerment demand. Investigators established the circumstances of his exposure. They established Tate's condition at the time. They built a case that reflected the full weight of what had been lost, not just a young life, but a young life that was lost entirely because of choices made by an adult who was responsible for keeping that child safe. Natalie Tate was charged and brought before Maricopa County Superior Court. The legal proceedings addressed both the specific events of September 2024 and the broader context of the circumstances that had led to Jody Jackson's passing. On March 6, 2025, Natalie Tate was sentenced to 12.5 years in prison for the passing of her son. The sentence represented the court's assessment of the full scope of the failure that had resulted in Jody's death, a failure that was not the product of a single bad moment, but of a sustained set of choices that had created the conditions in which an 18-month-old boy was left vulnerable to something that took his life. 12.5 years. It is a sentence that will generate, as sentences in cases like this one always do, a range of responses. There are those who will feel that no sentence is long enough when the victim is a child. There are those who will see in the sentence an acknowledgement of the disease model of addiction and the complex factors that surround it. There are those who will focus entirely on what Jody Jackson deserved: a safe home, a present and capable parent, an 18-month-old birthday, and a second year, and a third year, and all the years after that. What is not in question is that Jody Jackson deserved to live. That his 18 months of life were not a sufficient amount. That the person responsible for him on the day he was exposed to something that ended his life had the obligation, as every parent has the obligation, to ensure that the environment around their child was safe. The fentanyl crisis in Arizona, as in communities across the United States, has claimed lives with a speed and reach that has overwhelmed families, communities, healthcare systems, and law enforcement agencies. It has entered homes. It has created circumstances of danger that affect not only the person using the substance, but everyone in their household, including, in this case, a child of 18 months who had no way of protecting himself. For parents who are struggling with substance use, resources exist specifically for families navigating this challenge. The Substance Abuse and Mental Health Services Administration, SAMHSA, operates a national helpline at 1-800-662-4357, available 24 hours a day, every day of the year, free and confidential. That helpline is a lifeline. For a parent in crisis, using it is an act of love for their children. Jody Jackson was 18 months old. His name deserves to be said. His story deserves to be told. And the accountability that was delivered in Maricopa County Superior Court on March 6, 2025, deserves to be recorded as part of the public record of what happened to him, so that he is not simply a statistic in a larger crisis, but a child with a name and a face and a life that mattered. Don't forget to like this video, leave a comment for Jody, and subscribe to Cold Case Hour. Your support makes it possible to keep telling the stories of children who cannot tell them for themselves. Case 10, Retta Renee Cruse. September 2021. Maricopa County Superior Court. City of Phoenix, Arizona. There is a particular quality to the cases that begin with a welfare check. A neighbor who noticed something. A relative who had not heard from the family in too long. A building manager responding to a concern. Someone, somewhere, with the instinct that something was wrong even before they had the language to say precisely what that wrong thing was. It is often the welfare check, the arrival of law enforcement at a door that opens onto something the first responders were not prepared for. That becomes the moment a case begins. The moment the silence breaks. The moment what had been happening inside a home becomes visible to the world outside it. In September of 2021, in Phoenix, Maricopa County, law enforcement responded to a welfare check at an apartment. Inside, they found two girls, a 9-year-old and a 4-year-old. Both children were unresponsive. Both were in a medical state that demanded immediate emergency response. The girls were transported to a medical facility. The scene they had been found in triggered an investigation that would eventually bring the case of Retta Renee Cruse before Maricopa County Superior Court. The investigation that followed the welfare check in September of 2021 worked to establish what had happened to these two girls, what had caused them to be found in the state in which they were found, and who bore responsibility for it. The investigation pointed to poisoning. The allegation that emerged from the investigative work was that the two girls, a 9-year-old and a 4-year-old, had been exposed to a substance by their mother, Retta Renee Cruse, that had caused the medical crisis in which law enforcement and first responders found them. Two sisters, a 9-year-old and a 4-year-old. The age gap between them matters because it situates them in two entirely different stages of childhood development. The 9-year-old was old enough to have memories, to have friends at school, to have a sense of herself and her place in the world. The 4-year-old was in the full earliest bloom of childhood, the age of imagination and wonder and the total trust that young children place in the adults around them. Both of them were inside that Phoenix apartment in September of 2021. Both of them were found unresponsive. As of the time of this documentary, 2026, the case of Retta Renee Cruse is moving toward trial in Maricopa County Superior Court. The legal proceedings have been working through the complex investigative and evidentiary record that this case has generated. The charges against Cruse reflect the severity of what investigators believe occurred in that apartment in September of 2021. Cases that move slowly through the legal system, and there are many, for reasons that include the complexity of the evidence, the need for thorough pretrial preparation, and the requirements of due process, do not move slowly because the system does not care. They move at the pace they move because the justice system is designed to be thorough. Because the stakes of a criminal trial, for the accused, for the victims, for the families of everyone involved, and for the community watching, are high enough to demand that every step be taken carefully and completely. For the two girls at the center of the Retta Renee Cruse case, the 9-year-old and the 4-year-old found unresponsive in that Phoenix apartment in September of 2021, the legal process underway in Maricopa County represents the community's commitment to ensuring that what happened to them does not simply disappear into the administrative machinery of a court calendar. It represents the insistence that their experience will be examined, that the facts will be established, and that accountability will follow wherever the evidence leads. What happened in September of 2021 in Phoenix is still being fully adjudicated as of 2026. The trial that is coming in Maricopa County Superior Court will be the public accounting of that event, the moment when a jury will hear the full record of what investigators found, what the evidence shows, and what the law requires. Two sisters, a 9-year-old and a 4-year-old. They were found unresponsive in their home. And the justice system of Maricopa County, working at the pace and with the thoroughness that justice demands, is moving toward a full reckoning with what the evidence shows happened to them. For children who are living in circumstances of danger that the world outside their home cannot immediately see, and there are many, in Phoenix and across Arizona and across this country, the community welfare check that prompted the response in September of 2021 stands as a reminder of why community vigilance matters. A neighbor who noticed. Someone who made a call. That call brought first responders to an apartment where two girls needed help. That call is why this case exists in the legal system at all. The Arizona Department of Child Safety accepts reports of concern about child welfare at 8775-437633. Reports can be made anonymously. If you have a concern, please make the call. The welfare check that begins a case like this one starts with someone being willing to say, something is not right. I am going to say something. Retta Renee Cruse's trial is coming. Maricopa County is watching. And the two girls who were found in that apartment in September of 2021 deserve the full and complete accounting that the justice system is working toward on their behalf. Their story does not end with the welfare check. It continues through the courtroom. And it will continue to be told here on Cold Case Hour as developments unfold. This has been Cold Case Hour. 10 cases. 10 sets of victims. 10 sets of lives that were changed or cut short by the actions of the people who should have protected them most completely. 10 cases being examined here not for shock value, not for sensationalism, but because the truth of what happens to children in our communities deserves to be told plainly, seriously, and with the full weight of respect for every person these cases touched. If you made it to the end of this documentary, you already understand why this work matters. You already know that stories like these are not just crime content. They are community history. They are accountability records. They are the public acknowledgement that children whose names might otherwise be forgotten deserve to be remembered by the people who share the world with them. Please like this video. Please leave a comment. Please subscribe to Cold Case Hour if you have not already done so. Hit that notification bell so you are the first to know when new cases drop. Share this video with someone who you think should hear these stories. Your engagement is not just a number on a screen. It is the thing that keeps this channel able to keep doing this work. The children in these 10 cases deserved better. By watching, by staying until the end, by sharing this content and engaging with this community, you are part of the collective refusal to let their stories disappear. That matters more than you know. This is Cold Case Hour. We will see you in the next one.